Court of Law is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Morning. Good morning, counsels. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-012, People of Guam Plaintiff Appellee v. Michael Gregory Rosal Jr., Defendant Appellant. Appearing for Defendant Appellant is Attorney Peter C. Perez. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Perez reserves 10 minutes.
You may proceed, Mr. Perez.
Good morning, Chief Justice Torres. May it please the court. Your Honors, this is a case where I considered filing an Anders brief. But if I was going to file an Anders brief, I would have to go through the record and identify the potential issues or state that there were no issues. And in doing so, this court does have prior precedent, which says, as a matter of legal technicality, that under the facts of this case, that plain error occurred. This is a case where the trial judge attempted to do something beneficial for the defendant. And this is a case where the defendant has already served probably 1,400 days in jail. So he's already significantly underway on his sentence. But what happened was he submitted through counsel, as a matter of strategy, a straight up plea in writing. It wasn't a plea agreement between the government and the defense. And the court held change of plea hearings, but it appears inadvertently the court did not. Well, number one, it appears that Rosal did not actually plead guilty on the record. And therefore, the court did not apparently accept a guilty plea on the record. Also, if we look at AGCA 6050 and the requirements for a guilty plea, as I briefed when we go through those, it appears the court did not make those advisories or make a determination that the defendant understood those advisories. On the other hand, we do have this kind of extensive writing, which does talk about rights and waivers of rights and the charges to which the defendant was offering to plead. And it did talk about sentencing ranges. And, those are part of the record, but it's not part of the colloquy. So there wasn't that colloquy that appears to be required.
We know it's plain error, right? The analysis here.
Right.
And so even if we agree that the court erred in not taking the formal plea on the record and going through the entire advice to the defendant upon his plea of guilty that's set forth in 6050, how are your client's substantial rights affected? And what is the or a miscarriage of justice that threatens the integrity of the judicial process? I mean, you even acknowledged that the judge seemed to be wanting to help your client,
Right.
In this situation.
We almost didn't even want to pursue the appeal. I've spoken to my client about it, but the Chung case appears to say that it's automatic plain error when there doesn't appear to be a clear, intelligent, knowing guilty plea, and when the 8 GCA 60.50 is not complied with, that it's automatic plain error. I'll quote the.
But hasn't the U.S. Supreme Court, 6050 is based on Federal Rule of Criminal Procedure 11, and it seems like the U.S. Supreme Court has held that if you have at least a single Rule 11 error, that doesn't constitute structural error. You're saying anytime we should adopt the position that anytime you fail to comply with 6050 in its entirety, it's structural error?
I don't think I would advance that position. I think that this court has already examined that, and I can't quote you the case. It might actually be the Chung case, but citing another case, I think this court had reviewed this before, and there might have been an instance where all of 6050 was not technically complied with, and did not vacate the plea. But in this case, Chung appears to be factually on point, and it said that the record was devoid of any action by the trial court to satisfy the requirement, the requirement being the judge's duty to inquire whether a defendant understands the nature of the charges to which he's pleading guilty. That appears to have been the case here. So I think the judge intended to, and then because the parties started talking about mitigation, that I think it just got accidentally overlooked.
So, Mr. Paris, number one, I'm glad that you did not file an Anders brief. I think you did a very good job in pointing out some of the shortcomings that occurred and when the defendant decided to plead straight up. And I think this is more a follow-up of the Chief Justice's question in terms of substantial rights and prejudice. And I don't know if this has been thought out, in terms of what may be the practical effect at the end of the day, should you prevail. Because it seems to me that, your client, in pleading straight up with possession with intent to deliver, was facing a minimum of 20 and up to 30 years. Plea agreement says 32. He ended up with a 10-year sentence under a provision, as you pointed out, where the trial judge was trying to help someone who is a drug offender addict that seemingly possesses the drug for his or her personal use. And that appeared to allow the judge or give the judge authority to avoid the minimum 20 years incarceration for the conviction that the charge that he pled to. But to me, if you do prevail, and this goes back for a new plea colloquy, your client faces 20 to 30 years upon resentencing. And as you know, I've read the transcript. It is suspect in reference to whether or not your client, who pleads straight up to possession with intent to deliver, is primarily possessing the drug for personal use because of his or her habit. And so there's going to be a new sentence entered as a result, where your client faces 20 to 30 years. And the mitigating circumstances don't appear to be that straightforward in my mind. And so I'm just wondering, at the end of the day, what is the practical effect? I think you did a great job in terms of showing that there potentially may have been error in entering into the plea colloquy, but it seems that your client came out ahead in this
Right.
particular circumstance.
Maybe one way to resolve it is if this court found that the Henderson presumption may be applied, and maybe that Manley applied. And maybe this court could consider that collectively, based upon the record, looking at the straight up plea, maybe the discussions between counsel and the court, that was sufficient to avoid plain error. My dilemma was trying to avoid was ethical. So
I think that's quite difficult to examine, looking at the Henderson presumption. First of all, I don't think the Henderson presumption applies other than to explaining the nature of the offenses. It doesn't apply to the maximum penalties that are set forth by the statute. It doesn't apply, I think, to the advice of whether or not you're entitled to, you're waiving your right to a jury trial or your right to self-incrimination. So I don't know that looking at the Henderson presumption alone satisfies, the fact that there might be error in this case.
And in addition to Mr. CJ, if I just may add, there, in reviewing the transcripts, there does not appear to be the foundation laid that there was this exchange between counsel and the defendant, at least not on the record, that I'm able to glean from the transcripts.
Right, apparently not at the change of plea hearings, but maybe in prior hearings, there were discussions between the court and defense counsel about how they were proceeding, and that counsel and client had discussed the plea. The other, to me, the problem with this case is that the defendant actually didn't plead guilty on the record, unless the court was going to say that the writing itself is the guilty plea, and that the record demonstrates an acceptance of that plea by the court because it went to sentencing.
Are you, I was a little, just as a follow-up to the question that was asked, I wasn't sure what remedy you wanted, whether you wanted us to vacate the conviction and essentially go back to ground zero so he could decide whether to enter into a plea agreement or not, because, he submitted the plea agreement, it wasn't accepted by the court. So, or did you just want us to vacate the conviction and go back for a new plea hearing and a colloquy with the judge? I mean, that wasn't clear to me, because you just asked to vacate the conviction. Well, if we vacate the conviction, it seems, and that there is no valid binding plea agreement. I mean, what's to prevent him from, at the change of plea, saying, I don't want to plead guilty now, I want to go to trial?
Really, I don't think we want we really don't want the plea agreement vacated. But
I thought you said there was no plea agreement.
well, there's a writing evidencing an intent to plead. The court, he never pled guilty in open court orally. There's indications that was the intention.
But is that binding? I mean, normally, we've analyzed plea agreements in the context of contractual obligations, and in the absence of acceptance by the court, is the plea document what is referred to as I think it was called I have it right here, plea of guilty and waiver of constitutional rights. It's not, and it was, of course, drafted presumably by the alternate public defender and not by the attorney general in negotiated basis.
Right. Well, he could have just gone in even without a writing and pled straight up. The court could have done that. I mean, there are just problems with the record.
But I mean, if the defendant, if we reverse, hypothetically speaking, and vacate the plea, vacate the judgment, and the defendant then has to re-enter a plea, it would seem to me that this may be a ripe case or a good case for a negotiated plea with the defendant has already spent, like you mentioned, over 4.5 years in prison, at least over 4 years. And instead of the possession with intent to deliver, a simple possession, may provide a better basis in which to invoke the exception of the mandatory, facing the mandatory 20 to 30 years for the straight up plea that he entered into. It would seem to me that Mr. Tennyson is he's a very reasonable person, and there may be a remedy that counsels can work out in this case.
I mean, maybe one possibility is for the court to stay the appeal and see if and refer the parties to settlement.
Mr. Paris, isn't this an issue fundamental to the justice system? That people knowingly waive their rights and knowingly enter a plea of guilty? Isn't that what you're saying?
Well, yes, it is, but as a matter of technicality, it is. But what is the practical benefit to the appellant?
How many times have you been in a plea hearing and it has to stop because the defendant didn't understand what was happening or couldn't state the factual places? I think it's fundamental to the process of a guilty plea.
I
Well,
think it's more than just a legal technicality. I mean, there's an
Right.
importance for wanting to ensure that the defendant understands the nature of the offenses, the fact that he's waiving his right to self-incrimination, the maximum penalties so he can make a voluntary and willing plea.
Right, and Your Honor, I'm not trying to diminish it. When I say legal technicality, I mean in response to what's the practical effect? Because the practical effect, we have this apparent error. So I mean, I would ask that the court stay the appeal and let the parties and refer the parties to see if they can resolve it. Alternatively, if I filed an Anders brief, I just don't think I could have filed that.
Yeah, I'm not following that because you've laid out that the government has, there may have been shortcomings and that that the defendant was never pled in open court and the various 60-50 provisions were not adequately explained. Those are substantive issues in reference to ensuring that there was a knowing, intelligent, valid waiver of his constitutional rights.
If the court was open to staying the appeal, to give the parties the opportunity to discuss it, any potential errors might be cured.
Does it make a difference in terms of our analysis as to whether or not there was compliance with 60-50 or whether the defendant was aware of the nature of the offenses and all of the rights that he was waiving, that the defendant and his counsel were the ones that prepared and submitted the document versus one that was done by the AG's office? Or
I mean, I think what it would suggest is, since it was drafted by defense counsel, that he would have done that with the authority of his client, but I don't think it technically cures it. I think the problem is that we have this precedent, and I'm not saying the precedent is a problem. I'm just saying for purposes of the analysis, the precedent is a problem because it says that it's automatic plain error. So, I mean, I think the way for parties to fix it is to fix it among themselves. And I think they can if given the opportunity. But that would be trial counsel's role. Well, I mean, maybe it could be my role, but
well, I'm not sure they would have jurisdiction unless we remanded, and I'm not certain that that's something that, I mean, potentially if it was done as a settlement at the appeal level, that might be an option, but perhaps we should hear from Mr. Tennyson on that point.
so maybe I'll just stop.
Mr. Tennyson? You weren't trial counsel, that I can be sure.
Thank you. Chief Justice, may it please the court. This is a unique case, and the people don't contest that there's error under 60-50. That's not up to dispute. It's unique that when I first got the case and was reading through it, surely there's a checklist and we run through it. And that process was just derailed due to discussion about mitigation and trying to getting ahead. And then the trial court tried to get back on track, and then the people responded, and then it just kind of went off the rails from there. There's a couple potential solutions here. And what it really comes down to is, how far does the court want the Henderson presumption to apply? How much deference do you give trial counsel on this kind of an issue? I think, and I think that this court stated in Chung regarding 60/50, it's not a constitutional mandate, these rules. These are procedural safeguards in place that the hope is, if we go through these processes, the trial court does asks on each of these 4 subjects, we're going to make sure that the defendant makes a voluntary, knowing, and intelligent plea of guilty. That's the constitutional safeguard. That's the right to due process. That someone doesn't go in, plead guilty, and has no assistance, no support, doesn't know what they're pleading guilty to.
How does the court judge that when they just have a written document?
Um,
And how do they know these rights were knowingly waived?
the case law I've seen indicates, and more is federal practice, to the best way to establish that is by asking the defendant in open court, the trial court asking. The people have really had to, and I think the weakness for the people in this case is a lot of this is inference. I mean, we have an August hearing where trial counsel for the defendant states, I talked to my client, he's going to plead guilty. Trial court asks, Mr. Rosal, did you talk to your attorney about this? Yes, I did. That's the extent we have for Henderson presumption. And then the argument there goes into, we look at the change of plea. There is an intent to plead guilty. The defendant trial court lists the charges. You know, you intend to plead guilty to this. Yes, yes, yes. Never says the magic words, I plead guilty. And in my review, there's also some concern I have, since all these issues are interrelated. And my first thought was, where's the factual basis to support the judgment? And that's HEA 6070. Factual basis of plea required. The court shall not enter a judgment upon a plea of guilty unless it's satisfied that there's a factual basis for the plea. And as we look through the change of plea, there's no real statement of facts. Now, this statute is really, the goal here is to make sure that someone isn't pleading guilty to something they didn't do, and to make sure that they understand the elements, and that can be intent, that can be other things. And Moore's federal practice talks about, well, you can get that from the pre-sentence report. If the trial court doesn't get it in the change of plea, you can get that from other sources. The record as we have it now isn't sufficient to make that analysis. And that isn't actually, I believe, an issue of first impression in Guam. There's a split in the circuits as to how they do review a factual basis attack. Ninth Circuit, United States v. Matthews, 833 F2D 161, has stated that Ninth Circuit has at least held that by pleading guilty, you waive that approach, but that hasn't been decided here. That's still first impression. But that's another issue too. If this were to be stayed, that could be resolved, that could be mitigated, because I think under that issue, there's a potential for habeas. And even if perhaps a bit of a stretch based on just the somewhat dearth in the trial court record of just a little more substance, less inference. If the Henderson presumption does apply, this is a theoretical if, it is a presumption, it is rebuttable, and that is an ineffective assistance of counsel issue, which is also habeas. And if the Henderson presumption ever were found to apply, it is rebuttable, and that's how there would still be a remedy. But it's really up to this court as to how far does it want to put the Henderson presumption to work. In regards to staying and resolving it, I think it can be done. I have a few procedural concerns. So if the court, well, first let's talk about reversal. So if the court was to reverse, I think the reversal is based on, and I think it has to be based on a finding that the plea isn't voluntary, wasn't knowing, wasn't intelligent. That would be from a function of just lack of information to infer that. If the, the people's argument to not reverse depends on Henderson presumption applying. If the Henderson presumption doesn't apply, you can't meet some of the requirements under 6050, and you can't infer that. Case law is clear, you can't infer it, has to be in the record. So if we stay it to resolve the issue, if you do reverse it, the plea is void from case law I've seen. Now, the plea is void. My concern becomes there's a written statement in the record of Mr. Rosal pleading guilty. That isn't going to be voided out. That's something for the trial court. I mean, I don't know if that can be withdrawn or not. Trial court does have some discretion over that, but as a matter of evidence, it's a statement against interest. I'm not sure how that would play out. If it were to go back down and say, I changed my mind, I don't want to plea, I want to go to trial. What happens with that written plea of guilty, waiver of constitutional rights? I don't know. The big concern on staying, and I think that the Supreme Court would need to be involved if the parties can reach a resolution, because the trial court has no way of modifying the sentence after it's been entered on the agreement of the parties without a statute. If it's reversed, then that's not an issue. We just go through the process again. But at this point, if we were able to resolve it here, I think that stays subject to the Supreme Court's jurisdiction. There'd be some kind of a agreement or understanding between the parties as to what a solution is. And I think that's going to look something along the lines of Mr. Rosal deciding he does want to pursue his plea of guilty, some kind of statements in the record acknowledging, showing it's knowing, voluntary. And that's something that maybe with remand or after decision of the court could be filed in the trial court once it's approved for form, just to establish in the record it's there. And then the Supreme Court could enter an order providing whatever relief is necessary. I don't know what that would look like, whether that be modification of something or another remedy that would be subject to discussion of the parties in the court, this court determining reasonableness, appropriateness, and if it solves the
But that has to come
defects.
from the parties,
Yes.
Mr. Tennyson. This court can't sentence
No.
the defendant. I mean, in reference to the results that are ultimately achieved, that has to come between the two parties to the
Yes.
case.
Yes, you're correct, Your Honor. And I think that would be the trial court as well. So while the Supreme Court wouldn't be the one sentencing, I think it could be a remand or something to the trial court to effectuate it. And that way, the trial court has a basis to enter the remedy when the statute might be silent on it.
There may be a potential if it's done as a settlement conference based on the entire case at the Supreme Court level.
Mhm.
Just as you would we have a rule that allows appeals to be set to a settlement and potentially done in that manner.
Yes, Your Honor, and have at least experience with one of those. And I think that would, if a path forward can be identified, that would be
I
the
don't think
appropriate
we've done it in a
process.
criminal case before.
That one I would need to look into.
It's not to say that other jurisdictions have not, in fact have, I think, but.
And I think the issues raised here are things that could be discussed in such a forum because they implicate the defendant's substantive rights, and those rights can be waived under appropriate circumstances with agreement and review of the court, just to make sure that everything is in order and the trial court can be informed and take their appropriate steps. My general argument has deviated a bit from how I expected. Let me just see if I had any real notes.
I do have another question. Part of the statement or the writing is a waiver of appeal, but you didn't raise that in
Yeah.
your argument.
No, we didn't, and perhaps could have, but based on the direction of the court, I mean, there's always a right to appeal. And if the record was more clear, I think there's a stronger basis to argue that it's been waived. But I would want the trial court to ask, you realize you can't appeal, you're waiving that, you know that, right? The level of that kind of a waiver, and all the waivers, I mean, we can look at the written plea and I would suggest that trial counsel, if I was trial counsel and trial counsel for the defendant, experienced public defender, I would expect that Attorney Santos had these discussions with his client. It's just, that's a lot to infer from a plain statement of, did you talk to your attorney? Yes, I did. And counsel says, I talked to him as well. What did you talk to him about? It's not discussed.
Yeah, seems they were a little sloppy. I mean, and you pointed out the reasons why they kind of got ahead of themselves talking about the mitigation and didn't go back and actually the judgment of conviction references the plea being accepted on August 15th. But on that record, the court talks about we'll do the change of plea later. So
And no one, it wasn't really caught because even they had the second change of plea hearing, and at one point in the transcript, the trial court states, you know, I believe we did the colloquy, we did the finding of fact, and defense counsel agrees. The largest concern I've just had on this is there is error. No question about that. You know, we need to infer regarding voluntary knowing and all that. I think that's the problem, but it's really, for me, what's the substantive harm? There's other cases where clearly, you know, they changed the plea at the last second. It's a different statute, and the defendant's clearly railroaded in a way they don't understand the intent or an element. And we just haven't really seen that here. That's something that can be cleared up if it's stayed and we go to settlement, I suppose. My largest concern with this is it really is just the what was the expectation? Where was the confusion of the plea guilty, the plea of guilty? And that's an issue you get to after you find that there isn't a substantive violation. And if Henderson doesn't apply,
I haven't
what
seen
we had.
cases where Henderson's applied other than to the nature of the offenses and you know, I haven't seen it applied to like 60/50B
Mhm.
or C, you know, dealing with the other provisions.
And those are the ones that are a little more, I think those are the ones that, for example, just the nolo contendere, you know, he does ask him, do you understand the difference between guilty and nolo contendere? He says yes, but they don't discuss, you realize there will be no further trial.
Yeah.
I mean, you know, he does say we're going to sentencing, defendant doesn't object, but there's no clear statement for
And I
B.
think here, what's especially troubling to me is the penalty that he faced, provided by law that's required, you know, telling him the max. Because it seemed like the trial judge himself wasn't sure and all. And I
And-
think you know, in order for a defendant, it would seem would really have to know.
Mhm.
And it looks like the plea agreement even differed, you know, I think it said 32 versus, you know, so I think there
Yeah.
was a lot of,
There was a bit of discussion. No, the numbers do change, Your Honor. I think it's the plea, the guilty plea says maximum of 32. I think the trial court said maximum of 30, or someone else said something else. So, I mean, the general consensus is it's 30 or more, but there's just differentiation as to what the maximums are. And that, if we don't have certainty on that, how can you knowingly? So on that point, I think the people would concede that this is a fitting case for potential settlement. And then the parties will can figure out how to proceed and how to handle some of the procedural issues just to make sure that everything can be done properly. And if we can't, then I suppose the court would be able to take this up on the merits and make its determination. I've really pretty much covered all the issues I had just regarding 60/50 Henderson presumption. And the real question here is, was it voluntary, knowing, and intelligent? 60/50 is a safeguard to get there, but even if you don't have exactly in the forum under 60/50, you can reach it. The court just needs to decide, can that be inferred here? Or not even inferred, can it be found in the record reliably? So
Just in terms of one other check items in reference to you addressing all the issues. The provision that the trial judge relied on, section 67.401.4, the mitigating
Mhm.
factors that allowed, seemingly allowed in the judge's mind, the deviation from serving or imposing the mandatory minimum and allowing for a lesser sentence than the mandatory minimum of 20 years. So do you feel that on this record, those mitigating factors were satisfied that allowed the trial judge to exercise its discretion in applying that provision?
For that issue, and that's an issue I've cursorily had people discuss and I've thought about a little bit. I haven't fully analyzed the record for that basis to see if there's sufficiency in there. I know there's a pre-sentencing report, but I haven't reviewed it. I mean,
It would seem to me that the statutory provision that was charged here, possession with intent to deliver, may be inherently inconsistent with the provision that you are possessing the drugs primarily for your personal use because you're a drug addict. And so it was just difficult in my mind to resolve how you can apply exercising that discretion with someone coming and pleading straight up to possession with intent to deliver, having money, having the drugs, having a substantial amount of cash available.
yes.
So I was just having difficulty as to whether or not that could be satisfied with this charge.
Yes, and I apologize. I'm laughing because I have an image of my head of, this is more of a business thing, but you know, what percentage of your funds from the sales were spent for your own personal usage? What did you use to buy equipment to help you further your enterprise and sell more drugs? You know, there might be a basis for a finding of that nature, but I think it would be quite a extensive finding, and it would probably involve quite a bit of detail about the method of distribution, when distribution took place, the numbers of the amount of money brought in from it, you know, the amount of product that was sold.
And what would someone have to do to prove that he or she was an addict? Just simply saying on the record that I'm a user and I'm dependent on it? Or is there medical evaluations that would need to be provided on the record?
Yes, you know, I think the defendant's statement is a part of it, but there are medical evaluations, there's psychiatric evaluations, there's family and colleagues and friends as well who can come in and testify and say, this is the impact it's had on this person's life. They used to be like this, now they're like this. And with a medical professional as well, they can identify, there are formal medical diagnoses for addiction. That would be I think a minimum bar for that kind of a determination. Because otherwise you do just have a self-serving statement, might be an accurate statement.
Well, I'm raising these points because if we're going to stay this, the parties are going to work out a plea agreement, and the current charge is possession with intent to deliver with a mandatory minimum.
Mhm.
And on this record, there's nothing to support the exercise of discretion in terms of section, whatever that
Mhm.
provision is, the
Yes,
opt-out section or the provision that allows for lesser than the mandatory minimum for a drug offender's personal use. That can be challenging.
yes, Your Honor. And that ties into the factual basis aspect of this as well to support the conviction. And as I indicated earlier, I mean, there could be something in the pre-sentence report. I haven't seen it and we haven't brought that into the record, but there is definitely a evidentiary showing required beyond simple statement from the defendant that I'm an addict. But I do think that can be provided. It just requires a number of witnesses and expert testimony to establish. And that's another issue we might be able to look at and resolve through some kind of discussions. But
Because there needs to be some kind of authority to deviate from the current
Mhm.
charge of possession of intent to deliver. Otherwise, it's a mandatory minimum of 20 years.
Mhm. And I think that if there's resolution to that, it'll be in the creation of a factual record that can be put into the trial court. Whether that be through affidavit declaration, I don't know. We'll need to figure that out. If that's the direction the court would like to go in terms of staying in settlement discussions. And if there's no other questions, the people will rest. Thank you.
Mr. Paris?
I really think that the best way to resolve these various issues and potential future issues is for the appeal to be stayed and let the parties try to cure everything. It sounds to me like people are open to resolving it. To the extent that we can do it on an appellate level, I would work with counsel to try to resolve it and with my client. Otherwise, I mean, we just need to figure out the mechanics of how we would ask for it to be resolved, but it sounds like there's an openness to resolving it and curing the problems. I would ask that the court allow us to do that.
Just in follow-up to the Chief Justice's suggestion, is this something that councils can do on their own, or is this something that a settlement judge would be helpful in trying to help resolve?
I think in my experience, I'm typically able to resolve most cases without a settlement judge, but sometimes a settlement judge is helpful. Maybe the parties could explore trying to settle among themselves first, and then if they can't resolve it within, say, 2 weeks, to then ask. It depends on how long the court gives us a stay for. If it gives us a stay, you could give us parameters. The parties can't resolve it within 2 weeks and want to avail themselves of the settlement judge, notify the court within such a period of time. I think we could do it on our own, though.
All right. If there's nothing further, the court will take the matter under advisement and will now stand adjourned.
Thank you.
All right.